Good morning. I hereby call to order this 16th meeting of the Pennsylvania Public Utility Commission for the year 2024. We welcome everyone joining us here in the room today, as well as those joining us on the live stream. In honor of Veterans Day, which our nation observes this weekend, I now welcome Chris Brown, Deputy Chief Counsel of the PUC's Law Bureau, to lead us in the Pledge of Allegiance. Chris served in the United States Air Force as a captain and a senior navigator. He was an electric warfare officer on the B-52 and mission commander on the EC-130H. Please stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Chris. At today's meeting, which is open to the public, the Commission will act on various matters. Since adequate forms have been made available for public participation in cases before the Commission, there is no opportunity for the public to address the Commission at this public meeting. Public meeting motions, statements, and video will be available on the Commission's website later today. The first matter on this morning's agenda is the approval of the minutes of the meeting of September 26, 2024. I would like to recognize Commissioner Yonora as the editor of the minutes. Commissioner Yonora.
Chairman, I review the minutes for the September 26, 2024 public meeting and move that they be approved as submitted.
Thank you, Commissioner Yonora. Is there a second?
Second.
Second by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. The minutes are approved by a vote of 5-0. Madam Secretary, welcome back.
Thank you,
We are
Mr.
ready
Chairman.
for your... Go ahead.
Thank you
Ready
very
for your
much.
presentation.
Thank you, Mr. Chairman. Thank you, Commissioners and the staff of the Commission for your support and prayers during a very difficult couple months. Thank you. Good morning, Mr. Chairman and Commissioners. Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by Director Monahan and the Bureau of Audits. It is recommended that the Commission adopt in an omnibus motion both items on page 1, beginning with the Management and Operations Audit and Implementation Plan of the National Fuel Gas Distribution Corporation, and ending the omnibus with the audit report of Herman Oil and Gas LLC and releasing both audit reports and the implementation plan to the public.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. Matters passed by a vote of 5-0. Madam Secretary.
Turning to page 2, in matters presented by Director Hafner and the Office of Special Assistance, it is recommended that the Commission adopt in an omnibus motion both items on page 2, beginning with the formal complaint of Terry and Betty Bente versus the Metropolitan Edison Company, and continuing the omnibus to include the first item at the top of page 3, ending the omnibus with the security certificate filed by the Pittsburgh Water and Sewer Authority.
Is there a motion to consider the staff recommendations? So moved. Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye. Aye. Those opposed, no. Ayes have it. Matters are approved by a vote of 5-0. Madam Secretary.
Continuing on page 3, it is recommended that the Commission adopt the proposed opinion and order in the application of American Broadband and Telecommunications Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yonora, seconded by Vice Chair Barrow. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Prior to joining my staff, Kayla Ross worked in I&E, and she worked on this case. She has not advised me. That's it.
Thank you. Any further discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. Matter passes by a vote of 5-0. Madam Secretary.
Turning to page 4, it is recommended that the Commission adopt in an omnibus motion both items on page 4, beginning with the formal complaint of Florence Ackridge versus the Philadelphia Gas Works, and continuing the omnibus to include both items on page 5, ending the omnibus with the application filed by PennDOT regarding a rail crossing in Beaver County, Pennsylvania.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Commissioner Coleman. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0, and matters passed. Madam Secretary.
Turning to page 6, it is recommended that the Commission adopt the proposed opinion and order in the petition filed by the PECO Energy Company regarding its default service program.
Is there a motion to consider the staff recommendation?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Yenora. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. I believe that PECO's default service settlement is reasonable. The settling parties agreed, well, one issue I have a problem with. The settling parties agreed that for contracts executed after June 1st, 2025, PECO would allow EGSs to advertise products through PECO standard offer program that would not automatically renew with the same EGS. Instead, customers would be returned to default service. Returning standard offer customers to default service at the end of a standard offer program term does not, in my opinion, violate the Commission's regulation at Section 54.10. That section states that if customers do not affirmatively choose to return to default service upon receipt of mandated end-of-contract notices, they will then be transitioned to automatic contract renewal with the same EGS. Section 54.10 does not prohibit giving customers the option at the beginning of the contract to make the choice to return to default service when that contract ends. PECO proposed to get the customer's consent at the beginning of the standard offer program contract to return that customer to default service once the standard offer contract ended. So to me, that makes sense. Making a customer wait until the notices go out at the end of the standard offer program does not make sense to me. So to read Section 54.10 in the manner that the settlement opponent's request would effectively require EGS contracts to accept automatic renewal. I don't believe that the regulation was intended to prohibit the flexibility of a contract to not automatically renew. Contracts with automatic renewal provisions will still be available on the open market, but the standard offer program should no longer require the EDCs to advertise them on behalf of the EGSs. Shopping is not new in this state. I don't think that they need the leg up there. I'm concerned that the standard offer program contracts may be misunderstood by customers who do not realize that renewals can result in much higher prices. By comparison, when a customer goes out onto the open market and shops, they are more likely to understand the risk and the obligations to shop carefully. PECO's proposed settlement should be approved as being in the public interest. Thanks.
Thank you, Vice Chair Barrow. Any further comments?
Mr. Chairman.
Commissioner Zerfus.
Mr. Chairman, I'd like to associate myself with the comments of the Vice Chair. I also believe that the non-unanimous settlement filed in this case should have been approved in full without modification. I would have supported the settlement provisions relating to the solar procurement and the various provisions that benefit the residential customers. However, I do not support the modification of the settlement relating to PECO standard offer program and would have been in favor of the settlement provision allowing customers to return to default service upon the conclusion of their SOP contract. So for these reasons, I'd like to concur in part and dissent in part, but I understand you need me to pick one or the other for the purposes of recording a vote. So I would like to be recorded as a no. Thank you.
Thank you. Any further discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no.
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 The ayes have it by a vote of 3-2, noting the dissents of Vice Chair Barrow and Commissioner Zerfus. Madam Secretary.
Continuing on page 6, it is recommended that the commission adopt in an omnibus motion the remaining item on page 6, the petition for reconsideration filed by Go Green Taxi LLC, and continuing the omnibus to include both items on page 7, ending the omnibus with the application filed by ML Shirk Transport LLC.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second?
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matters passed by a vote of 5-0. Madam Secretary.
Turning to page 8, it is recommended that the commission adopt the proposed opinion and order in the petition for interim emergency order filed by Total Energies Distributed Generation USA LLC.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfas. Any discussion? I do have a motion. I would ask Vice Chair Barrow to chair the meeting.
Chairman, I recognize you for purposes of your motion.
Thank you, Vice Chair. I ask that my motion be entered into the record as though I read it in its entirety. On September 30th, 2024, Total Energies Distributed Generation USA, LLC, filed both a petition for interim emergency relief pursuant to Section 3.6 of the Commission's regulations and a formal complaint pertaining to the same matter regarding a PPL Electric Utilities, Inc. customer generator interconnection approval process. Total Energies is a developer of renewable energy projects and has made several customer generator applications for net metered solar generating facilities in the PPL service area. Total Energies object to PPL adopting a deposit requirement for customer generator developers of net metered renewable energy for alternative energy projects. The deposit would require the customer generator to pay PPL for complex engineering, interconnection equipment, and other elements. The deposit is 25% of the total cost and is non-refundable. Total Energies' petition for interim emergency relief sought to enjoin PPL from imposing this non-refundable deposit requirement pending final disposition of the corresponding complaint. On October 15, 2024, following a hearing, the Office of Administrative Law Judge issued an order granting the petition for interim emergency relief filed by Total Energies and certifying a material question to the Commission as required by the Commission regulations. On October 22, 2024, however, Total Energies and PPL filed a joint letter in which the parties asserted their agreement that PPL would not require non-refundable deposits from Total Energies while the formal complaint was pending. The letter specifically stated, quote, "To save the time and effort involved in briefing the issue and the Commission's time and effort in reviewing the matter, PPL Electric and Total Energies have reached an agreement that will eliminate the need for the Commission review of the interim emergency order," end quote. The letter further stated that such deposits will remain refundable unless the Commission in its ruling on the complaint case declares that such deposits shall be non-refundable. The parties requested that the Commission take whatever action may be required to effectuate the agreement. As a result, neither Total Energy nor PPL filed a brief regarding the material questions certified by the ALJs on October 15, 2024. Based on the assertion in the October 22, 2024 letter, the petition for emergency relief and ensuing material question should be deemed moot. Although Section 5.305 of the Commission's regulations regarding interlocutory review of material questions does not specifically allow the Commission to deem a material question moot, under the circumstances present in the current matter, we exercise our discretion to liberally construe this provision of our regulations, since no substantive rights of the parties are affected. That is, since neither party wishes that we answer the material question, we will refrain from doing so. The parties' agreement that such deposits will remain refundable unless the Commission rules otherwise in response to the complaint is reasonable and will be adopted. Therefore, I move that 1, that the material question certified by the Office of Administrative Law Judge on October 15, 2024 will be deemed moot to secure the just, speedy, and inexpensive determination of the matter. 2, that the petition of Total Energies Distributed Generation USA LLC for interim emergency order is marked closed. 3, that any questions regarding the legality of the deposit requirements and furtherance of interconnection applications on the PPL electric system are referred to the matter at docket number C-2024-305-1475. And 4, that the Office of Special Assistants prepare an opinion and order consistent with this motion. Thank you, Vice Chair.
Thanks, Chairman. Is there a second to the motion?
Second.
Seconded by Commissioner Yenora. Any discussion on the motion? Hearing none. All those in favor of the motion say aye.
Aye.
Aye. Any objections? Okay, on final adoption, is there any objection to using the previous roll call? Thank you. The recommendation is adopted as amended by the motion by a vote of 5-0. Gavel's yours.
Thank you, Vice Chair. Madam Secretary.
Turning to page 9, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion both items on page 9, beginning with the application of the Baltimore-Washington Telephone Company, and continuing the omnibus to include both items on page 10, and ending the omnibus with the first item at the top of page 11, the application filed by Enhanced Communication Network.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Vice Chair Barrow. Any discussion? Hearing none. All those in favor, please say aye. Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing on page 11, it is recommended that the Commission adopt the proposed order in the letter of notification filed by PPL Electric Utilities Corporation regarding a transmission line in Bucks County, Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Yenora. Any discussion?
Chairman, I have a motion.
Vice Chair Barrow.
Thank you. Please add this motion to the record as though read in its entirety. On June 7, 2024, PPL filed this letter of notification seeking to reconductor a section of their Springfield-Gilbert 230 kV line in Bucks County. That line connects the Springfield substation in Bucks County, Pennsylvania, to the Jersey Central Power and Light owned substation in Hunterdon County, New Jersey. Back in November 2020, the New Jersey Board of Public Utilities requested that PJM open a competitive proposal window to solicit project proposals identifying transmission projects to address New Jersey's public policy goals for 7,500 megawatts of offshore wind in New Jersey by 2035. PPL states that reconductoring a section of this Springfield line is necessary to resolve thermal violations resulting from that work. So in effect, this application is for the purpose of a generator interconnection project in New Jersey. However, I believe that it should be granted for 2 reasons. First, in other generator interconnection contexts, like here, the utility and its ratepayers do not bear the cost of the upgrades. Although the present application might be somewhat speculative because of New Jersey's offshore wind, that's not yet ready to come online. In other generator interconnection applications that the Commission has approved, the same has been true. Transmission upgrades always precede the interconnection of the generation. Because of that, the Commission may exercise discretion when reviewing the need for the project. The present LON is entirely within the utility's property. No new right-of-way is needed. Combine that with the lack of ratepayer cost, and I believe that the project meets the needs standard under the Public Utility Code and our regulations. Second, this project is needed to support New Jersey's public policy needs, and it is funded by New Jersey ratepayers. The state agreement approach utilized here saves money for those states, like us, who do not have the same public policies and aligns cost appropriately. The commission should not impose unnecessary application requirements on those projects where there is little burden on Pennsylvania's interest. And also, approval of the project comports with the General Assembly's direction in Chapter 28, which directed us to work with other states to encourage functional interstate power pools. Therefore, I move that the letter of notification filed on June 7, 2024 by PPL Electric Utilities Corporation is granted, and that the Bureau of Technical Utility Services shall prepare an opinion and order consistent with this motion.
Thank you, Vice Chair Barrow. You've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. Motion is approved by a vote of 5-0. On the matters amended by the motion, is there any objection to taking the previous roll call? Hearing none, matters passes as amended by the motion by a vote of 5-0. Madam Secretary.
Finally, on page 11, it is recommended that the commission adopt the proposed order in the letter of notification filed by PPL, Electric Utilities Corporation, regarding a transmission line in Cumberland County, Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, second by Commissioner Yanora. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. Please add this statement to the record as though read in its entirety. This is another letter of notification. It was filed July 16, 2024. PPL is requesting approval to reconstruct sections of an existing 230 kV transmission line at the expanded Cumberland substation in Silver Spring Township, Cumberland County. They say the reason for the work is to avoid thermal overload. The transmission facilities in this case are similar to the facilities that were the subject of the application filed by MATE last year. I dissented on that MATE application. This one, I believe, is distinguishable from MATE's in that here, PPL explains that the current configuration puts approximately 50,000 customers at risk of electric outages, includes 9 critical customers such as hospitals, a wastewater system, and nursing homes. Compared to MATE, the evidence in the instant case presents a much more serious risk to customers should the multiple contingency event here occur. So that is, to me, that shows a much clearer need, and just wanted to explain the difference between the two. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. The matter passes by a vote of 5-0. Madam Secretary.
Turning to page 12, it is recommended that the commission adopt in an omnibus motion both items on page 12, beginning with the application of Auction Your Energy, LLC, and include and end the omnibus on page 13 with the security certificate filed by the Pittsburgh Water and Sewer Authority.
Is there a motion to consider the staff recommendations?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Yanora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matters passed by a vote of 5-0. Madam Secretary.
Turning to page 14, and matters presented by Chief Counsel Screven and the Law Bureau, it is recommended that the commission adopt in an omnibus motion both items on page 14, beginning with the petition for reconsideration filed by Environ Energy, LLC, and ending with the proposed final order regarding the Act 129 total resource cost test.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and the matter is passed by a vote of 5-0. Madam Secretary.
Turning to page 15, in matters presented by Chief Administrative Law Judge Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt the initial decision of ALJ Haas in the formal complaint of Barbara Dickey versus the Pennsylvania Electric Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yenora, seconded by Commissioner Coleman. Any discussion?
Mr. Chairman, I have a statement.
Commissioner Zerfus.
Mr. Chairman, Madam Secretary, I have a statement in this matter. Please add it to the record as if I read it in its entirety. I will not. I will just very quickly summarize. The long and short of it is Ms. Dickey, the complainant, was not provided adequate notice of her hearing, in my opinion, in this matter. I believe she should have been afforded the opportunity for another hearing consistent with Commission precedent. So because of this, I will be a no on this matter. Thank you.
Thank you. Any further discussion?
Chairman,
Vice Chair Barrow.
for the reasons voiced by Commissioner Zerfus, I'll associate myself with her statement.
Any further comments? Hearing none, all those in favor, please say aye. Aye. Those opposed, no.
No.
The ayes have it. Matter passes by a vote of 3-2, noting the dissents of Vice Chair Barrow and Commissioner Zerfus. Madam Secretary.
Continuing on page 15, it is recommended that the Commission adopt the initial decision of ALJ Coogan in the formal complaint of the Bureau of Investigation and Enforcement versus Planet Energy, doing business as Ritterate Energy, doing business as Value Plus Energy.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, second by Commissioner Yenora. Any discussion? I do have a motion in this matter. I ask Vice Chair Barrow to chair the meeting.
Thank you, Chairman. I recognize you for the purpose of your motion.
Thank you. I ask that my motion be entered into the record as though I read it in its entirety. Before the Commission is the initial decision of Administrative Law Judge John Coogan issued on August 29, 2024, which approves the settlement filed by the Bureau of Investigation and Enforcement and the Planet Energy Corporation, a licensed EGS. The settlement resolves allegations brought by I&E in its formal complaint filed on June 1, 2023, which alleges that Planet Energy failed to comply with several Commission regulations governing notification for changes to or abandonment of contracts by licensed EGSs. The Office of Consumer Advocate and the Office of Small Business Advocate filed notices of intervention on July 13, 2023, and on July 24, 2023, respectively. I&E alleges that from January until October of 2022, Planet Energy terminated nearly 5,700 fixed-rate contracts for Pennsylvania customers with no prior notice. I&E alleges that customers were unaware that their contracts had been terminated until they received notice from their utility that they had been returned to default service. As noted in the initial decision, Planet Energy's Canadian parent company was experiencing financial distress that led it to cancel these Pennsylvania contracts. I&E initially sought a civil penalty of $500 per customer for a total of $2.845 million. Planet Energy subsequently entered bankruptcy protection. Exhibits provided by the company showed that it had $42.7 million in liabilities, but only $10 million in assets, making recovery of any penalties in this case unlikely. In the settlement, the parties agreed to a civil penalty of $1 million. Planet Energy also agreed to surrender its EGS license and never do business in Pennsylvania again. The actions of Planet Energy in this case, if proven, would constitute gross violations of Commission regulations of its responsibility as a licensed supplier. The settlement terms, specifically, the civil penalty amount, appropriately reflect the severity of the allegations while considering the complicating factor of the parent company's bankruptcy. However, I believe it is necessary to propose a modification of one of the settlement terms. In the settlement, I&E agrees not to pursue collection of the $1 million civil penalty. I find it against the public interest for the Commission to impose civil penalties while waiving its rights to even attempt to pursue them. This would signal to other potential bad actors that even egregious business practices could go unpunished simply because the pursuit of Commission-imposed penalties may be difficult. As such, I believe that the settlement should be modified to remove any provisions stating the Commission will not pursue the civil penalties imposed on Planet Energy, as those provisions are contrary to the public interest. Preserving the integrity of Pennsylvania's retail electricity market is an essential function of this Commission, and no entities licensed by this Commission should operate under the premise or misapprehension that its penalties are meaningless. Therefore, I move that 1, the initial decision of Administrative Law Judge John M. Coogan be modified consistent with this motion. 2, that the Bureau of Investigation and Enforcement, Planet Energy Corporation, doing business as Right Rate Energy, doing business as Value Plus Energy, the Office of Small Business Advocate, the Office of Consumer Advocate, as parties to this proceeding, shall have 20 business days after the entry date of the tentative order to file comments. 3, that should any adverse comments be filed, the proceeding shall be assigned to the Office of Special Assistance for the drafting of a final opinion and order. 4, that should no adverse comments be filed, the tentative order shall become final. 5, that the Bureau of Investigation and Enforcement and Planet Energy Corporation, doing business as Right Rate Energy, doing business as Value Plus Energy, may elect to withdraw from the modified settlement within 20 days after the entry date of the tentative order modifying the settlement. 6, that if the Bureau of Investigation and Enforcement and Planet Energy Corporation, doing business as Right Rate Energy, doing business as Value Plus Energy, elect to withdraw from the modified settlement, the settlement shall be void and the proceeding returned to the Bureau of Investigation and Enforcement without any assignment to the Office of Special Assistance. 7, that the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you, Vice Chair.
Thank you. You've heard the motion. Is there a second on the motion?
Second.
Seconded by Commissioner Coleman. Any discussion on the motion? I do have a conflict statement. Kayla Ross, who works for me, when she worked in I&E, she worked on this case. She has not advised me on this. Okay, so any further discussion? Nope, hearing none. All those in favor of the motion say aye.
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 Aye. Any objections? On final adoption, is there any objection? Is there any objection to using the previous roll call vote? Nope. Hearing none, the recommendation is adopted as amended by the motion by a vote of 5-0.
Thank you, Vice Chair. Madam Secretary.
Turning to page 16, it is recommended that the Commission adopt the recommended decision of ALJ Hoyer regarding the rate tariff supplement proposal and joint petition for settlement filed by the Duquesne Light Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfas. Any discussion? I do have a statement I would like to submit for the record. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. Matter passed by a vote 5-0. Madam Secretary.
Continuing on page 16, it is recommended that the Commission adopt the recommended decision of ALJ Brady in the petition filed by PPL Electric Utilities regarding its default service and procurement plans.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Unora, seconded by Commissioner Zerfas. Any discussion?
Chair, I have a statement.
Vice Chair Barrow.
Thank you. Please add my statement into the record as though read in its entirety. The settling parties here arrived at a reasonable resolution of the default service plan as a whole, but given the choice between PPL's proposed time of use plan and retention of the current time of use plan, I do prefer the plan proposed by PPL in its petition. I have all sorts of reasons for that. I will refer you to my written statement. Thank you.
Thank you, Vice Chair Barrow. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Mr. Chairman, that concludes regular agenda. Turning now to the carry-in. On page 1 of the carry-in agenda, it is recommended by the Office of Special Assistance that, consistent with 4 PA Code, Section 1.43C, the notational vote taken by the Commission in the joint petition for an interim emergency order regarding the Venango Water Company be recorded and entered in the minutes of this public meeting.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Yenora. Any discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 2 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order selecting the contractor for geophysical engineering services to the Bureau of Investigation and Enforcement Safety Division.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. Matter passed by a vote of 5-0. Madam Secretary.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you. Before we adjourn today, I wish to provide a few remarks in recognition of Veterans Day, which our nation recognizes every November 11th. It is a time to celebrate and honor our nation's servicemen and women of the armed forces of the United States. It is also time to acknowledge the many sacrifices they must make. Veterans play a strong role in our public utilities and in our state and our national workforce as a whole. Today, we again wish to recognize the many men and women of our Public Utility Commission who have served or are serving in our armed forces. We are proud of our many PUC employees who have answered the call. I also wish to recognize one of my fellow commissioners as being part of that list. Commissioner Yenora, we thank you for your service in the Pennsylvania Army National Guard. At this time, I invite all veterans in the hearing room today to please stand to be recognized. To all of you, we thank you for your service to our country, and we salute you. I encourage everyone to thank a service member this weekend, and also take the opportunity to attend one of the many Veterans Day ceremonies hosted by various organizations in our communities. If there's no other business to come before us, is there any objection to adjourning today's meeting? Hearing none, we are adjourned.